Assalamualaikum. My name is Nuedina binti Muhammad Nazri and I will be the first presenter presenting on the first issue, which is the right to know the ground of arrest and also to hire, talk or consult with legal representation, which is like lawyers and so on. First and foremost, the right to know the grounds of arrest, and this is clearly stated in the Federal Constitution and specifically in Article 5, Liberty of Person. And I shall read it to you. Article 5, subsection 3, which stated, where a person is arrested, he shall be informed as soon as may be of the ground of his arrest and shall be allowed to consult and be defended by a legal practitioner of his choice. This can also mean that anyone who is arrested by the authority, may it be police or so on, they have the right to know from the authority the ground of their arrest, the reason behind them being arrested as soon as may be. And when it comes to saying as soon as may be, which is a reasonable time, they get to know the reason why as soon as they were arrested by the authority. Moreover, as I have read Article 5 of the Federal Constitution, subsection 3, at the end of the clause it says, be defended by legal practitioner of his choice, meaning that one arrestee or one individual who was arrested by the authority, they have the right to talk, hire or consult with any legal practitioners that they prefer to. And this is for them to defend themselves against the reason or the ground of the arrest that they gone through. This article can be backed up with the case of Nik Adli bin Nik Abdul Aziz against Ketua Polis Negara, where the judge stated that the plaintiff liberty was deprived due to the police not informing the reason or the ground behind the plaintiff's arrest during the remand, which go against the Article 5 subsection or clause 3 in the Federal Constitution that I have just read earlier. What does the word as soon as may be written in Article 5 clause 3 in Federal Constitution means? This can be explained in the case of Aminah against Superintendent of Prison in Kelantan, which the judge explains that the word as soon as may be here means as soon as in reasonable time, meaning that the best one means that as soon as the arresting action take place, as soon as the authority proceeds with the arresting action, they have to tell straight away to the arrestee the reason behind this action is taking place. As soon as the arrestee is cuffed or taken into custody, meaning that is the time where the authority have to tell the arrestee behind the reason of that arresting action take place. In the case of Yit Hon Kit against Minister of Home Affairs, the authority took 57 days to tell the arrestee the reason behind the arresting action, and according to the court, it is considered as unreasonable time. Furthermore, in the case of Chong Kim Loy against Timbalan Menteri Hal Ehwal Dalam Negeri, the judge stated that the words or the language used to communicate the grounds does not have to be in strict terminology. What does it mean here? It means that the word or the language used by the authority to communicate or to inform the grounds of the arrest to the arrestee does not have to be in strict terminology, as long as the language or the words used by the authority to inform the arrestee of the ground of the arrest is understood by the arrestee, and that is enough to be considered as the ground have been communicated to the arrestee. While in the case of Ramli bin Saleh against Yahya bin Hashim, the court explains about the right to counsel. The police have the right to not tell the ground of arrest to the arrestee if the police can prove that by them telling the ground, or by them here means the authority, to meet legal practitioner or legal representation, the arrestee to meet legal representation or any fanciful grounds, the police have to prove that that action by the arrestee can impede or stop or delay the investigations by the authority. Looking back at the question where Tisha and her friends are not informed by the authority of why they are arrested, the ground of their arrest, can be considered as against the Article 5, Clause 3, because just like in the case of Nik Adli and Nik Abdul Aziz, it is considered not unconstitutional for the authority to not tell the ground of the arrest. Same goes to the case of Tisha and her friends, where Tisha and her friends are not informed by the authority of the ground of their arrest for as long as 7 days. That is also considered as unreasonable time, just like the case of Yit Hon Ki. Therefore, Tisha and her friends have the right to know the ground of their arrest and also have the right to meet legal practitioner that they prefer, because this right is protected under the Federal Constitution under Article 5, Clause 3, when the authority did not tell Tisha and her friends about the ground of the arrest, and also not allowing Tisha and her friends to meet, consult, or hire any legal practitioner for 7 days long of their remand, which is Tisha and her friends' remand, means that the authority have go against the Article 5, Clause 3 in the Federal Constitution, which also depriving Tisha and her friends' right. Let's not forget that Tisha and her friends were also not allowed by the authority to meet, talk, consult, or hire their preferred legal practitioner or their legal representation to protect Tisha and her friends from the authority or from the arrest. This action by the authority not allowing Tisha and her friend also go against the Article 5, Clause 3 in the Federal Constitution. Plus, there is no emergency declared in the case of Tisha and her friends. Therefore, Tisha and her friends' right to know the ground of their arrest and also to meet legal practitioner, to meet, talk, hire, or consult legal practitioner or legal representation to defend Tisha and her friends are still valid. That right of Tisha and her friends are still valid because there's no emergency declared in their case. According to Section 28 of the CPC, or known is Criminal Procedure Code, where the police should tell Tisha and her friends, or should allow Tisha and her friends to communicate, hire, talk, meet, consult with their legal practitioner, their preferred legal practitioner, as soon as the police investigation starts. Yet, according to Section 117 of the CPC, or the Criminal Procedure Code, the denial of the legal practitioner to meet or consult or communicate the legal practitioner rights by the authority to Tisha and her friends can be considered as constitutional if it is postponed due to the incompleteness of the police investigations. So that will be all for the first issue of the rights to know the ground of the arrest and also to consult with legal practitioner. So for the second issue of this question of Tisha and her friends, I will pass on to my groupmates to answer the question. Thank you for listening.
The right of speech and expression and the restraint on this fundamental liberty is provided under Article 10, Clause 1. The first, every citizen has the right to freedom of speech and expression, and B, all citizens have the right to assemble peacefully and without arms, and C, all the citizens have the right to form associations. These provisions are not only confined to oral and speeches, but can be imposed in written and also social media. Under constitutional law, it is generally understood that freedom of speech and expression is a combination of many rights in many forms. Freedom of speech is not only applied to normal citizens, but also to legal entities like companies, corporations, and statutory body if they are incorporated or established under Malaysian law. However, regarding into cyber speech, since the Federal Constitution was drafted back in 1957, when technology has yet to be advanced, the Constitution will not have anticipated the cyber age. Article 10, Clause 2, Para A of the Federal Constitution authorizes Parliament to impose such restriction on the freedom of speech as it deems necessary or expedient on the following 8 grounds, which is the security of the Federation, which is the first is friendly relation with other countries, morality, privilege of the parliament, contempt of courts, defamations, and also incitement to any offense. For example, here in Malaysia, we have Defamation Act 1957 and the Sedition Act 1948 to govern those areas. As I mentioned before, when Parliament may impose restriction on the freedom of speech and expression, the acts I stated earlier can be used and function well to preserve peace and harmony. Here are two cases that are related to the situation. The first case is PP and Param Kumaraswamy. Here the facts of the case are the defendant was charged with bringing hatred or trying to contemn or to excite disaffection against any ruler. In Sedition Act of 1948, Section 3 provides that a seditious tendency is a tendency to bring into hatred or contempt or to excite disaffection against any ruler or against any government. Here, the intention to incite violence or public disorder is not actually necessary, but what matters most is to find the seditious tendency. To protect the liberty of speech and expression of any individual, the public prosecutor needs to find the seditious tendency in the words that have been spoken by the defendant, and the intention is not matter. The public prosecutor in this case failed to prove the seditious tendency, and the defendant has been acquitted. Now, for the second cases, which is the PP and OK side, the fact of the case are the defendant was charged with the offense of sedition under Section 4, Subsection 1, Para B of the Sedition Act 1948. The defendant was found to have uttered seditious words in his speech, in which he accused the alliance governments of practicing ethnic-based policy, on the grounds that the defendant uttered seditious words challenging the special position and privilege of the Malays under Article 152, 153, and 181. The judge found the defendant guilty of having uttered seditious words, which came within the Sedition Act 1948, Section 4, Subsection 1, Section 2, and Section 3, Subsection 1. What the prosecution has to prove is, in the judge ruling, is that the accused have actually spoken the words. The court noted that the right to freedom of expression is fundamental for any democratic institution. But he also noted that such as freedom is not an absolute right, but must be within reason to maintain an effective balance. Here we can see that two cases where the court has tried to approach differently by referring to the Seditious Act 1948.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Wafiq bin Abdul Rahim, and I will be sharing on the application and the conclusion for this second issue. So, firstly, the application. Generally, every citizen, including Tisha and her friends, is subject to the rights of freedom of speech and expression under Article 10 Clause 1A of the Federal Constitution. So, freedom of speech was given to Tisha and her friends, and is stated in the Federal Constitution, basically to enhance the protection of the fundamental rights for Tisha and her friends and the other citizens as well, and recognize that she and other citizens of Malaysia enjoys basic inalienable rights and liberties. So going a little bit in depth on the importance of rights of freedom of speech can be seen in the case of Pico and Connecticut, where the court held that the freedom of speech is an important requirement for almost all other rights. Without it, the people are unable to defend their rights, and freedom of speech is important to develop an individual self-expression, and it is said to be a form of open communication which enables the citizens to convey their claim and thus to defend their other rights. Moving on to the next application, which concerns the Sedition Act 1948. So the Sedition Act 1948 comes into picture in the situation where Tisha and her friends are actually being restricted to do what she did, which was posting on social media. Initially, the Sedition Act prohibits Tisha and her friends from doing any speech or publication in any form that is disrespectful towards the government or the sultans, such as the YDPA and the Energy, Climate Change and Environmental Minister. Not only that, it also banned people from being hatred among the three races and religion of Malaysia. However, Tisha and her friends' dissatisfaction is only a mere criticism as stated in Section 3, Subsection 2A, where Section 3, Subsection 2 provides certain exceptions providing examples of speech which cannot be deemed seditious. It is not seditious to show that any ruler has been misled or mistaken in any of his measures, nor it is seditious to point out errors or defects in the government or constitution as by law established. This is what can be seen was made by Tisha and her friends. So therefore, Tisha and her friends' dissatisfactions are not amounting and constitute to a sedition. And lastly, for my part, the conclusion for the second issue, Tisha and her friends' actions are not subjected with seditious wrong acts as their dissatisfaction is only a mere criticism and subjected to the exception in Section 3, Subsection 2A of the Sedition Act 1948.
Lastly, based on the third question, it's highlighted regarding the right of life and personal liberty. So, the issue whether Energy, Climate Change and Environment Minister have failed to take responsibility in solving post-flood effect, deprived life and personal liberty of Trisha and her friends under Article 5, Clause 1 of the Federal Constitution. As an illustration, based on the case of Tan Teck Seng and Suruhanjaya Perkhidmatan Pendidik and another, it was concerned with the procedural fairness and the constitutional right of a civil servant facing dismissal. So based on the Gopal Sriram JCA speaking for the Court of Appeal, posited that life under Article 5 means more than mere existence. It incorporates all those facets that are an integral part of life itself and those matters which go to form the quality of life. Of these are the rights to seek and be engaged in lawful and gainful employment and to receive those benefits that our society has to offer to its member. It includes the right to live in a reasonably healthy and pollution-free environment. So, for the purposes of this case, it encompasses that right to continue in public service subject to removal for good cause by resort to a fair procedure. Another example can be seen via Suhakam action in request the government to distribute free COVID-19 immunizations to all, notably underprivileged groups, refugees, migrants, stateless people, prisoners in detention centers, and jail inmates, without regards to nationality. So, Suhakam has states that in 2020, the government created the Special Committee on Ensuring Access to COVID-19 Vaccine Supply, which means JKJAV, to investigate issues with the purchase and distributions of the COVID-19 vaccine. Based on the government December 2020 updates, the current supply of the COVID-19 vaccine will enable 82.8% of Malaysians to obtain the vaccination. Everyone has the right to health, which it is a fundamental human right. So health coverage, especially vaccination, is an important component of the right to health. So the vulnerable populations, including refugees, migrant and undocumented employees and stateless people, are at the danger of sliding through the crack in the present health system for a variety of reasons, including their status and nationality, as well as their inability to pay for the health care. So it has been claimed that the country has roughly 2.5 million documented migrant workers, which does not include the number of unauthorized migrant workers because there is no clear statistic on this. In addition, COVID-19 infections have been reported in the detention center and prisons. As a result, when the government distributes the COVID-19 vaccination, this must be taken into account. Thus, Suhakam takes notice of press reports in the beginning of the January 2021 indicating that JKJAV intended to offer free immunizations to migrant workers in the country. So Suhakam expects that JKJAV will investigate this situation and provide free COVID-19 vaccine to everybody, particularly to migrant and undocumented workers, refugee, stateless people, prisoner in detention facility, and jail inmates. When we talk about Article 5 Clause 1 of the Federal Constitution, we must know what that article talk about. So, regarding Article 5 Clause 1 of the Federal Constitution says that no person shall be deprived of his or personal liberty save in accordance with law. The term of person in that article refer to a citizen as well as non-citizen who live in our country, which means it is applied to everyone and indeed talk about a person. Moreover, it might theoretically encompass juridical person which is a non-human legal person that is not a single natural person that an organization recognized by law as a fictitious person such as a corporation, government agency, non-government organization and international organization with whom the law can bestow legal existence. In addition, we also not to forget that Article 5 Clause 1 of the Federal Constitution also have mention about life. So when we do some interpretation about life, it's bring us to know about the right to live with the human dignity, which is the right of a person to be valued and respected for their own sake and to be treated ethically, as well as not merely refer to animal existence of breeding and living. So, therefore, human dignity includes a prisoner complaint of torture of or inhuman conditions of detention like solitary confinement, as well as necessities of life as adequate nutrition or clothing. Nonetheless, personal liberty can be referred as the ability of a person to act as their life, with the exception of any limitation put in the place by the law to protect the physical, moral, political, and financial well-being of others.
Assalamualaikum, my name is Alif and I will be presenting the application for the third issue. The authorities should take a prompt action in managing the post-flood condition instead of delaying in management and disposal of the domestic waters by the respective authorities. This is against the judgment in the public prosecutor and Sri Ulu Langat Palm Oil Mr. Sendirian Berhad as the minister failed to do so. As a result, the flood victims are exposed to the risk of being infected by spreading disease, particularly caused by red urine, and some of educational institutions were closed. Tisha's sister is one of the victims. The impact established has deprived the life of people in Sungai Besar, which right lay out in the Article 5 subsection 1 of Federal Constitution to enjoy life and personal liberty. The first case took place in Sungai Besar and affected some 4,000 people who sought treatment for high fever, headache, muscle pain, nausea and vomiting, and are suffering at the expense of their life. In conclusion, Tisha and her friends' action which addressed the failure of Energy, Climate Change and Environment Minister to take responsibility of the post-flood effect deprived life and personal liberty of Tisha and her friends governed under Article 5 subsection 1 of the Federal Constitution. I think that's all from us. Thank you.